Your arguments next in 73-1892, Weinberger against Wiesenfeld. You've got to return the time. Shevin gets time. Comes into 6. Shevin against Tom, revisited. Front here. This is Reed against Tom. Mr. Jones, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court, this case involves a claim of sex discrimination under the Social Security Act. Section 202G of that Act provides for the payments of benefits to certain widowed mothers. There is no comparable provision under the Act for payment of benefits to widowed fathers. The appellee in this case is a widowed father who claims that he is constitutionally entitled to the payment of benefits on the same basis as if he were a widowed mother. It is the government's position, as I will elaborate at some length later, that this statute, like the property tax exemption in favor of widows in Kahn against Shevin, serves the permissible legislative objective of ameliorating the harsh economic consequences of economic job discrimination against women, and that it should be sustained on that basis. A description of the operation of the Act is essential to an understanding of this case. The benefits payable under Section 202G are paid out or on account of the Social Security account of the deceased wage earner. The widowed mother receives, I think, a benefit equal to 3/4 of the primary insurance benefit that the deceased husband would have received had he lived and retired, reduced 50 cents for each dollar that the widow earns in excess of $2,400 per year. Payments are made to the widowed mother so long as she has a minor child in her care and remains unmarried. Similar benefits are provided under the Act to the child of a deceased wage earner. The child receives benefits on the basis of the Social Security account of his or her deceased parent. Whether or not the parent is the father or the mother makes no difference. But there is no provision under the Act for the payment of benefits to widowed fathers under the age of 60 on the basis of the account of their deceased wives. The appellee in this case is a young, unemployed widower. After the death of his wife, his child began receiving benefits based upon her Social Security account. He, however, was not entitled to benefits. By he, I mean the appellee, was not entitled to benefits himself under the Act. In view of this, he brought the present suit for declaratory and injunctive relief, contending that he was constitutionally entitled to a distribution of benefits on the same basis as if he were a widow rather than a widower. A 3-judge court was convened. The court determined that all sex-based classifications are inherently suspect under this court's 2-tiered equal protection analysis that it has applied in recent years. The court analyzed the statute and concluded that it did not serve a compelling governmental interest. And accordingly, the court held the statute unconstitutional and ordered the payment of benefits to the appellee as if he were a widow. The court stayed its order pending this appeal, and the case is now here on the government's direct appeal. At the outset, I think it can be said that the district court clearly erred in applying the compelling governmental interest standard of review. It has become clear in this court's decisions in Kahn against Shevin and last week in Schlesinger against Ballard that sex-based classifications are not inherently suspect. They're not subject to justification only on the basis of a so-called compelling governmental interest. They are not invalid per se. This is not to suggest that the traditionally permissive rational basis standard of review is fully appropriate in all sex discrimination cases. Sex-based classifications, we believe, do merit close judicial scrutiny, and they've received it by this court in the past. In Frontiero against Richardson and Reed against Reed, this court struck down sex classifications that merely serve the purpose of administrative convenience. Thus, the court has applied a standard of review which involves close scrutiny, but scrutiny which is not so strict as to be inevitably fatal. The rule that the court seems to be applying is simply that sex-based classifications must rest upon some substantial reasonable basis, or as Chief Justice Berger said in the Reed opinion, upon some ground of difference having a fair and substantial relation to the object of the legislation. As I will now show, the statute here in question easily meets that test. Appellee's principal attack on this statute is, curiously enough, not from the point of view of the widower who has been denied benefits, but rather from the point of view of the female wage earner who, it is alleged, is denied social security coverage for her spouse that would have been granted to a male wage earner. The appellee's argument proceeds syllogistically. First, the appellee analogizes the payment of Social Security taxes to the purchase of private insurance coverage. And the appellee contends that female wage earners are not granted the right to purchase the same insurance coverage that a male wage earner purchases for his spouse under this system. And appellee concludes that this discrepancy in treatment, this discrepancy in insurance coverage, is impermissible. We believe there are two fatal flaws to this chain of reasoning. First, the analogy to a private insurance scheme is itself fundamentally erroneous. As this court noted in Fleming against Nestor, the Social Security Act comprehends a scheme not of private, but of social insurance, under which benefits are distributed and coverage provided, in large part on the basis of probable need, rather than on the basis of rather than strictly on the basis of the contributions that the insured wage earner has paid. But even accepting for the moment the private insurer paradigm on which appellee relies, we think it's nevertheless clear that the female wage earner is not entitled to any additional insurance coverage under the Act, that the female wage earner has not been disadvantaged in any way. As we pointed out on pages 21 and 22 of our brief, female wage earners under the Social Security system pay in only 28% of all Social Security taxes, whereas 34% of the benefits paid out in the system are paid out on the basis of the Social Security accounts of female wage earners. Now, I'm not talking about the benefits that are paid to women. I'm talking about the benefits that are paid out solely on the basis of the women's accounts as workers. Now, this means that the Social Security system is already out of actuarial balance in favor of the female wage earner as against the male wage earner. If my rough arithmetical calculations are correct, right now the female wage earner receives a 33% greater coverage under the Act in terms of dollars than does the male wage earner. To grant the additional insurance coverage for which appellee contends here would simply further tilt the scales in favor of the female wage earner as against her male counterpart.
How do you account for the existing disparity?
I think in large part the disparity flows from the fact that women have longer life expectancies and that their retirement benefits are spread out over a longer period of time. It may also be attributable in part to the fact that lower wage earners are entitled to a somewhat greater return under the Act than are higher wage earners, and women statistically are lower wage earners. I think for those two reasons, and I'm not sure which is more important, women do receive, on the basis of their accounts, a far greater return than do men. And our position with respect to this argument, this insurance coverage argument by the appellee, is that to grant further coverage, to further tilt the scales in favor of women, obviously would not serve the purposes of the Equal Protection Clause. And it therefore seems to us that Appellee's insurance coverage argument simply reduces to the complaint that Appellee's individual wife, as a wage earner, unlike the average female wage earner, has been somehow disadvantaged, that the payments made on the basis of her account are in some sense constitutionally insufficient. There's no merit to this argument, either legally or factually. As a factual matter, I think that you can deduce from the record and that it is clear that Appellee's son has already, or will soon have, received greater benefits under the Social Security Act than his wife ever paid into the system, that there is no ground for viewing her account as being somehow disadvantaged. But more fundamentally, as a legal matter, there is no basis for an argument that a Social Security contributor has a vested interest in his or her Social Security account. That argument, which obviously is not a sex discrimination argument, was firmly rejected by this court in Fleming against Nestor, in language which I think is equally appropriate here, and I would like to quote. The Social Security system may be accurately described as a form of social insurance, whereby persons gainfully employed and those who employ them are taxed to permit the payment of benefits to the retired and disabled and their dependents. The non-contractual interest of an employee covered by the Act cannot be soundly analogized to that of a holder of an annuity, whose right to benefits is bottomed on his contractual premium payments. We therefore think it's clear that Appellee's wife, as a female wage earner, was not disadvantaged either in her individual capacity or as a member of a class under the Act, that she was not the subject, was not the victim of any cognizable discrimination under the Act. For that reason, I now turn to the Appellee's alternative argument, which is based upon the contention that the denial of benefits to a widower constitutes a denial of equal protection to men, as an impermissible discrimination against men. That argument, it seems to us, is foreclosed by this court's decision in Kahn against Shevin. In that case, this court upheld a special Florida property tax exemption that was granted only to widows and not to widowers. The objective of that legislation, like that of the statute here, was to ameliorate in some degree the economic difficulties that uniquely confront the lone woman who has lost her husband. The court, in that opinion, recited statistics showing that the average female worker earned approximately 40% of the income of the average male worker. And the court noted that this disparity in the economic capabilities would be exacerbated in the case of a widow vis-a-vis a widower, and that the difference in earning power between a widow and widower was probably even greater than that between women and men generally. Mr. Justice Douglas, writing for the court in that case, observed that while the widower can usually continue in his occupation, in many cases the widow will suddenly find herself forced into a job market with which she is unfamiliar, and in which, because of her former economic dependency, she will have fewer skills to offer. And it's also clear that the discrimination inherent in such a statute between widows and widowers is not impermissible. As Mr. Justice Brennan, who was dissenting on other grounds in that case, observed, it's permissible to distinguish between widows and widowers because only the former, and not the latter, are subject to discrimination as a class. And if I may quote again from the dissenting opinion, inclusion of needy widowers would not further the state's overriding interest in remedying the economic effects of past sex discrimination for needy victims of that discrimination. While doubtless some widowers are in financial need, no one suggests that such a need results from sex discrimination. On the basis of these considerations, the court in this case, Kahn against Shevin, upheld the Florida statute as resting upon some ground of difference having a fair and substantial relation to the object of the legislation. Well, precisely the same considerations govern this case. Congress recognized that the probable need of widows is greater than that of widowers, and it enacted Section 202G to provide for that need. In doing so, Congress merely acted as it has also done in behalf of other persons, such as aged dependent parents, who cannot be fairly expected to replace, by their own efforts in the job market, the loss of support that has been occasioned by the death of a family wage earner. Moreover, this provision, Section 202G, does not suffer from the vice of over-inclusiveness that led two justices of this court to dissent from the ruling in Kahn. The amount of the benefits payable under Section 202G is inversely correlated to the amount of the widow's earnings, so that the woman who has, in fact, successfully surmounted sexual job discrimination is not provided benefits under this act. Similarly, benefits are provided only to the widow with a minor child in her care, for whom the economic consequences of job discrimination are heightened by the fact that she must additionally provide competent child care during the working hours. At the same time, the benefits provided under this statute are considerably more substantial than those that were granted by the property tax exemption in Kahn. Therefore, it seems clear to us that Section 202G serves the permissible legislative objective of ameliorating the economic consequences of employment discrimination that widows with children suffer with heightened severity, and that it does so both more thoroughly and more carefully than did the statute in Kahn against Shevin. I would add at this point only one final point. At bottom, the Appellee's argument here is that benefits under the Social Security Act must be distributed without regard to sex, equally to men and women in all cases. Although we realize that program costs cannot be determinative in a case such as this, we feel it is nevertheless not without some significance that the cost of achieving this objective, of paying out all benefits without regard to sex, would be approximately $350 million additional dollars per year. The statistics are set forth on page 15 of the appendix. This additional money would have to come from somewhere. The Social Security system is supposed to remain in actuarial balance. Therefore, to pay out these additional benefits, either Social Security taxes would have to be increased, or some other benefit group, the benefits payable to some other group would have to be reduced. It is in this context that we feel that this court's statement in Dandridge against Williams is particularly appropriate. That is, that it does not sit to second-guess officials charged with the difficult responsibility of allocating scarce public welfare funds among the myriad of potential recipients. Now, to apply a judicial restraint of this kind in a case like this is not, however, to place the Social Security system in the iron grip of the status quo. Congress has recently considered sex-based classifications under the Act, and it has amended the statute to eliminate one of the major sex-based classifications by providing for the equalization of the method of computing retirement benefits for men and women. And it may well act to further reduce or ultimately entirely eliminate all sex classifications under the Act. But for the present, we feel that it's clear that the exclusion of widowers under Section 202G lies well within Congress's constitutional power to allocate welfare funds. For these reasons, we respectfully submit that the judgment below should be reversed.
Mr. Jones,
yes.
Do there remain in the Act any differentials based upon gender as to age? I know the basic one was eliminated in 1972.
That was the only one that I am aware of. I don't think there are any more that remain. Well, on age exclusively, now there are some provisions that discriminate between men and women on the basis of age. For example, a widower over age 60 may in some cases be entitled to benefits, whereas a widow might be entitled to benefits at an earlier age.
This is without regard to children.
Without regard to children, that's right. But I don't think there are many significant age qualifications in the Act remaining.
Well, apart from widows and widowers, is there another distinction that women beneficiaries on retirement have theirs computed that may retire at age 62, whereas on males it's age 65?
This was the difference that was eliminated in the 1972 Act.
Who did that?
Congress.
It's on page 15 of your appendix. Under
That's
the,
correct.
the
Pages
chart.
14 through 16 discuss the...
Well, maybe, but haven't you brought a case here that we have pending, sir?
Well, we moved to affirm the judgment of the three-judge district
I know,
court in
but
that case.
there is such a case here, isn't it?
That's correct. That's on the basis of a claim of a man who retired earlier.
That's right. Before the 72 amendments don't become effective until this year.
They're not retroactive. That's correct.
And they become effective in 75.
I think they were phased in over a period of
I
time.
just read the petition this morning, and what you tell us there is they become effective this year.
Well, this says that the new provision will become effective starting January 1973 and will be fully effective in January 1975.
Yes, I think that it's phased in over 3 years. It does become fully effective this year. That's correct.
Congress there elected to ignore the difference in longevity of women over men.
Well, in fact, men were disfavored under the old law. And
my point is, they ignored the fact that women as a category lived longer than men.
that's correct.
And that's within their
correct.
legislative discretion, I suppose you would say. They can ignore it or they can act on it.
That's right, Mr. Justice Berg. We don't think the Constitution places Congress in a straitjacket with respect to the determination of distribution of these welfare benefits. We think that either alternative is acceptable under the Constitution.
Well, the old law was more commensurate with the idea that men live longer than women.
Yes, an assumption which, if ever true, is no longer.
Well, that isn't supported by the American Experience Table of Mortality, or never has been, is it?
Not that I know of.
Well, wasn't the basis that they argued the distinction between 62 and 65 under the old law is the favored, compensated, disfavored class?
It did have the effect of providing women...
Wasn't that the government's argument?
Congressional theory.
I'm not sure exactly what the government's argument was in the motion to... We may be speaking of different cases. The one I have in mind is called Core against Weinberger.
I don't remember it by name.
But, of course, Congress doesn't have to be locked into favoring disadvantaged classes. If there are no further questions, I'd like to reserve my remaining
Very well,
time.
Mr. Jones. Mrs. Ginsburg.
Mr. Chief Justice, and may it please the Court. Stephen Wiesenfeld's case concerns the entitlement of a female wage earner's family to social insurance of the same quality as that accorded the family of a male wage earner. 4 prime facts of the Wiesenfeld family's life situation bear special emphasis. Paula Wiesenfeld, the deceased insured worker, was gainfully employed at all times during the 7 years immediately preceding her death. Throughout this period, maximum contributions were deducted from her salary and paid to Social Security. During Paula's marriage to Stephen Wiesenfeld, both were employed. Neither was attending school, and Paula was the family's principal income earner. In 1972, Paula died, giving birth to her son, Jason Paul, leaving the child's father, Stephen Wiesenfeld, with sole responsibility for the care of Jason Paul. For the 8 months immediately following his wife's death, and for all but a 7-month period thereafter, Stephen Wiesenfeld did not engage in substantial gainful employment. Instead, he devoted himself to the care of the infant, Jason Paul. At issue is the constitutionality of the gender line drawn by 42 U.S.C. 402G, the child in care provision of the Social Security Act. Congress established this child in care insurance in 1939 as part of that year's conversion of Social Security from a system that insured only the worker to a system that provided a family basis of coverage. The specific purpose of 402G was to protect families of deceased insured workers by supplementing the child's benefit provided in 42 U.S.C. 402D, where the deceased insured worker is male, the family is afforded the full measure of protection, a child's benefit under 402D, and a child in care benefit under 402G. Where the deceased worker is female, family protection is subject to a 50% discount. A child in care benefit for survivors of a female insured worker is absolutely excluded, even though, as here, the deceased mother was the family's principal breadwinner. This absolute exclusion, based on gender per se, operates to the disadvantage of female workers, their surviving spouses, and their children. It denies the female worker social insurance family coverage of the same quality as the coverage available under the account of a male worker. It denies the surviving spouse of a female worker the opportunity to care personally for his child, an opportunity afforded the surviving spouse of a male worker, and it denies the motherless child an opportunity for parental care afforded the fatherless child. It is Appellee's position that this threefold discrimination violates the constitutional rights of Paula, Stephen, and Jason Paul Wiesenfeld to the equal protection of the laws guaranteed them with respect to federal legislation by the Fifth Amendment. The care with which the judiciary should assess gender lines drawn by legislation is currently a matter of widespread uncertainty. The District of Columbia Court of Appeals recently observed in Waldy v. Schlesinger, decided November 20th, 1974, precedent is still evolving, and existing decisions of this court are variously interpreted by the lower courts. Appellant had urged in his brief that it would be sufficient if any rationality can be conceived for the overt sex discrimination operating against the Wiesenfeld family. But this court acknowledged in Reed v. Reed, 404 U.S., that the legislative objective there in question, reducing probate court workloads, did not lack legitimacy. Yet, in light of the differential based on gender per se, the court required a more substantial relationship between legislative ends and means so that men and women, similarly circumstanced, would be treated alike. Again, in the court's 8-1 judgment in Frontiero v. Richardson, 411 U.S., requiring the same fringe benefits for married men and women in the military, the court evidenced a concern to analyze gender classifications with a view to the modern world and to be wary of gross, archaic, and overbroad generalizations. As in the case at bar in Frontiero, the underlying assumption was wives are typically dependent, husbands are not. Hence, the statutory scheme in this case, as the scheme in Frontiero, favors one type of family unit over another. And in both cases, the basis for the distinction is that in the favored unit, the husband's employment attracts the benefit in question. Where the breadwinner is male, the family gets more, and where the breadwinner is female, the family gets less. Con v. Shevin, 416 U.S., and Schlesinger v. Ballard, this court's most recent expression, are viewed by some as reestablishing a slack or cursory review standard, at least when the defender of discrimination packages his argument with a protective or remedial label. Con approved Florida's $15 real property tax saving for widows. The decision reflects this court's consistent deference to state policy in areas of local concern, such as state tax systems, domestic relations, zoning, disposition of property within a state's borders. By contrast, national workers' insurance and no issue of local concern is in question here. The differential in Schlesinger v. Ballard, this court pointed out, did not reflect archaic, overbroad generalizations of the kind involved in Frontiero or in the instant case. Indeed, there might have been a certain irony to a ruling in Lieutenant Ballard's favor. To this day, women seeking careers in the uniformed services are barred by federal statute and regulations from enlistment, training, and promotion opportunities open to men. The court's majority thought it a mismatch for federal law to mandate unequal treatment of women officers, denial to them of training and promotion opportunities open to men, a denial not challenged by Lieutenant Ballard, but to ignore that anterior discrimination for promotion and tenure purposes. Perhaps most significantly, Con and Ballard are among the very few situations where a discriminatory advantage accorded some women is not readily perceived as a double-edged sword, a weapon that strikes directly against women who choose to be wives and mothers, and at the same time to participate as full and equal individuals in a work-centered world. But there could not be a clearer case than this one of the double-edged sword in operation, of differential treatment accorded similarly situated persons based grossly and solely on gender. Paula Wiesenfeld, in fact the principal wage earner, is treated as though her years of work were of only secondary value to her family. Stephen Wiesenfeld, in fact the nurturing parent, is treated as though he did not perform that function. And Jason Paul, a motherless infant with a child, with a father able and willing to provide care for him personally, is treated as an infant not entitled to the personal care of his sole surviving parent. The line drawn is absolute, not merely a more onerous test for one sex than the other, as in Frontiero and in Stanley v. Illinois 405 U.S. And the shutout is more extreme than it was in Reed, where a woman could qualify as administrator if the man who opposed her were less closely related to the decedent. This case, more than any other yet heard by this court, illustrates the critical importance of careful judicial assessment of law-reinforced sex role pigeonholing defended as a remedy. For on any degree of scrutiny that is more than cursory, 402G's conclusive presumption, automatically and irrebuttably ranking husband principal breadwinner, displays the pattern Justice Brennan identified in Frontiero. In practical effect, laws of this quality help to keep women not on a pedestal, but in a cage. They reinforce, not remedy, women's inferior position in the labor force. Appellant has pointed out that women do not earn as much as men and urges that 402G responds to this condition by rectifying past and present economic discrimination against women. This attempt to wrap a remedial rationale around a 1939 statute originating in and reinforcing traditional sex-based assumptions should attract strong suspicion. In fact, Congress had in view male breadwinners, male heads of household, and the women and children dependent upon them. Its attention to the families of insured male workers, their wives and children, is expressed in a scheme that heaps further disadvantage on the woman worker. Far from rectifying economic discrimination against women, the scheme conspicuously discriminates against women workers by discounting the value to their family of their gainful employment. And it intrudes on private decision-making in an area in which the law should maintain strict neutrality. For when federal law provides a family benefit based on a husband's gainful employment, but absolutely bars that benefit based on a wife's gainful employment, the impact is to encourage the traditional division of labor between man and woman, to underscore twin assumptions. First, that labor for pay, including attendant benefits, is the prerogative of men, and second, that women, but not men, appropriately reduce their contributions in the working life to care for children. On another day, the pernicious impact of gender lines like the one drawn by 402G was precisely and accurately discerned by Appellant, in common with every government agency genuinely determined to break down artificial barriers and hindrances to women's economic advancement. Appellant has instructed that employers' fringe benefit and pension schemes must not presume, as 402G does, that husband is head of household or principal wage earner. It is surely irrational to condemn this sex line as discriminating against women when it appears in an employer's pension scheme, while asserting that it rectifies such discrimination when it appears in workers' social insurance.
You say the appellant has taken these inconsistent positions. I assume it wasn't just his idea,
he was
promulgating that for private pension schemes, but that he was carrying out his understanding of a federal statute.
He was carrying out inconsistent congressional commands, guidelines that he issued pursuant to Title IX of the Education Amendments of 1972,
Right.
forbid recipients of federal money from making distinctions of this kind. In sum, the prime generator of discrimination accounted by women in the economic sector is the pervasive attitude, now lacking functional justification, that pairs women with children, men with work. This attitude is shored up and reinforced by laws of the 402G variety, laws that tell a woman her employment is less valuable to and supportive of the family than the employment of a male worker. Surely Paula Wiesenfeld would find unfathomable this attempt to cast a compensatory cloak over the denial to her family of benefits available to the family of a male insured. Nor does Appellant's rationalization for discrimination even attempt to explain why Jason Paul, child of a fully insured deceased worker, can have the personal care of his sole surviving parent only if the deceased wage-earning parent was male. Appellant has asserted that providing child and care benefits under a female worker's account would involve fiscal considerations. The amount involved is considerably less than was indicated some moments ago. He estimates the cost for this particular benefit to be 0.01% of taxable payroll in the appendix at 16, and other differentials are not now before this court. At the same time, he maintains...
Are you familiar, Ms. Ginsburg, with the little chart on the top of page 15 of the appendix?
Yes, I am.
Could you tell us which one of these are we talking about?
We're talking about...
Which number?
Let's see.
3?
We're talking about 3, that's right. Number of persons affected, 15,000. Estimated benefit,
20 million.
20 million, right. And that is the only one we're talking about in this case.
And the... Well,
Of course, there is a somewhat inconsistent argument made, and that is that the bulk of widowed fathers would not qualify for child and care benefits in any event, according to Appellant, because unlike Stephen Wiesenfeld, they would not devote themselves to child care, but rather to gainful employment. Budgetary consideration...
The children have to be under, what, 18?
Yes.
So
Child has to be a child entitled to child's benefits under the Act.
Which means, among other things, that he's under 18.
Yes. Budgetary considerations to justify invidious discrimination should fare no better in this case than such considerations fared in cases in which relatively larger cost savings were involved. For example, New Jersey Welfare Rights Organization against Cahill, 411 U.S., summarily reversing 349 federal supplement.
What is the justification for benefits with respect to children, persons under age 18, as distinguished from having the line at 21 or 24 or some other age?
I don't know why the age line was set, but it's for all benefit purposes under the Social Security Act. I think a distinction is made if a child is attending school after 18, but I'm not certain of that.
But you don't need a babysitter for
No, you certainly
12,
don't.
14, 16, 18-year-old people, do you?
That's right, and whether that Congress has gone too far in that direction is not of concern here. Certainly it has not gone too far when it considers that an infant, such as Jason Paul Wiesenfeld, might benefit from the personal care of a parent.
Well, is there any possibility that the reasoning for his claim depends somewhat on this age factor?
The reasoning
The
for...
justification? If the justification is not warranted, would that enter into it?
Presumably, the greatest need is for very young children, preschool children. And in many cases, the sole surviving parent, male or female, may not avail herself, as the statute now stands, of this benefit once the child gets beyond preschool age or school age. Remember that this is not a benefit that is paid automatically no matter what. There is an income limitation. Once you earn beyond, well, it was $2,400, $1 of benefit is removed for every $2 earned. So the parent who receives this benefit must be performing that function, must be performing the child care function.
I suppose we're not confronted with that age problem unless a 19-year-old brings an equal protection claim of some kind.
Well, with 18 years as the voting age now, I think that is probably unlikely. But in any event, comparing the cost analysis here with the New Jersey Welfare Rights Organization case, that case involved a wholly state-funded program for aid to families of the working poor. This court declared unconstitutional limitation of benefits under that program to families with wed parents. Unlike New Jersey Welfare Rights Organization, the case at bar presents no issue of federal deference, arguably due to state family law policy or any other local concern. And surely leeway for cost saving is no broader in federal workers' insurance than it is in a wholly state-financed and operated welfare program a program funded by general state revenues rather than by contributions of insured workers and their employers. Budgetary policy, like administrative convenience, simply cannot provide a fair and substantial basis for a scheme that establishes two classes of insured workers, both subject to the same contribution work rate. Male workers whose families receive full protection, and female workers whose families receive diminished protection. Finally, the appropriate remedy is correctly specified in the judgment below. That judgment declares the gender line at issue unconstitutional because it discriminates in violation of the Fifth Amendment against gainfully employed women, such as Paula Wiesenfeld, as well as against men and children who have lost their wives and mothers. The judgment enjoins enforcement of the statute insofar as it discriminates on the basis of sex. Extension of child and care benefits under Paula Wiesenfeld's account is unquestionably the course consistent with the dominant congressional purpose to ensure the family of deceased workers and the express congressional concern to ameliorate the plight of the deceased worker's child by facilitating a close relationship with the sole surviving parent. Unequal treatment of male and female workers surely is not a vital part of the congressional plan. Withdrawal of benefits from female parents who now receive them would conflict with the primary statutory objectives to compensate the family unit for the loss of the insured individual and to facilitate parental care of the child. Under the circumstances, extension of benefits to the surviving spouse of female insured workers, to the father who devotes himself to child rearing, is the only suitable remedy. It accords with the express remedial preference of Congress in all recent measures eliminating gender-based differentials, for example, 5 U.S.C. 7152, cited at pages 39 to 40 of our brief, and with this court's precedent in such cases as U.S. Department of Agriculture v. Moreno, 413 U.S., New Jersey Welfare Rights Organization against Cahill, 411 U.S., and Frontiero v. Richardson, 411 U.S. I did want to comment very briefly on the point made with respect to women receiving Social Security benefits that exceed the amount of their contribution. The reason for this, the prime reason, of course, is that women live longer than men. Most benefits are paid to retirement age beneficiaries, and women happen to be 58% of the population of persons over 65. That increases in time. They're about 54.5% of the 65-year-olds, 58.5% of the 75-year-olds, and about 64.5% of the 85-year-olds. But the critical point here is that payments to the elderly are based on the individual's lifespan, not on his or her sex, so that if a man should live to be 100, he will continue to receive benefits, and he won't be told, well, too bad, you should have died earlier. Only women receive payments for that length of time. In sum, Appellee respectfully requests that the judgment below be affirmed, thereby establishing that under this nation's fundamental law, the woman worker's national social insurance is no less valuable to her family than is the social insurance of the working man.
Thank you, Ms. Ginsburg. Do you have anything further, Mr. Jones?
Yes, thank you, Mr. Chief Justice. First, I would like to correct a typographical error on page 15 of the appendix. In item number 2, it says eliminate the dependency requirement of section 202D. That should be 202F. That's right. I would point out that the appellee here has distinguished Kahn against Shevin, on which we rely, or tried to distinguish it only on two bases. One is by relying upon the private insurance paradigm that a female wage earner is entitled to a certain amount of insurance coverage. I discussed that at length in my opening argument. Second is that Kahn, in some sense, represents deference toward state taxing policies that appellee claims would not be due to federal welfare policies. I don't understand as an analytical matter why federal distribution of public welfare funds should not be entitled to the same deference as state taxing policies. Appellee also argues that the child here somehow has rights independent from that of either parent. I see no basis for that. The child has his own benefits under the Act. His only claim here is that one of his parents didn't get benefits. That claim is derivative from the claim of the parent, cannot be analyzed separately
He's
from
sort of
it.
a third-party beneficiary, isn't he?
That's right.
I mean, the purpose of giving benefits to the parent is so that he can stay home and take care of the child, right?
Well, I don't think that this legislative history backs that up necessarily.
What is its purpose then?
Well, the legislative history shows that the purpose of the statute was to distribute benefits in accordance with the probable need of beneficiaries, and it was made on an individual and not on a family basis. And it simply represents the judgment that women who seek employment are less likely to find it than are men, and that if they do find it, they're likely to earn less than do men.
Yeah, but this doesn't, if there were no children,
if there were no children,
those conditions, those presumptive conditions would still prevail, wouldn't they?
If there are no children, the problems of job discrimination at least would not be exacerbated by the need to provide child care during the working hours. There is, I think, a justifiable difference between treatment of widows generally and the widows with minor children. If there are no further questions, thank you.
Thank you, Mr. Jones. Thank you, Ms. Ginsburg. The case is submitted. We'll hear our...
I also have to announce number 73, 1892, Weinberger, Secretary of Health, Education, and Welfare, against Wiesenfeld. Under the Social Security Act, when a covered male worker dies, leaving a wife and minor children, survivors' benefits are paid both to the children and to the widow. However, when a covered female worker dies, leaving a husband and minor children, survivors' benefits are paid only to the children and not to the widower. A three-judge district court in New Jersey held that this sex-based discrimination was unconstitutional because in violation of the equal protection component of the Due Process Clause of the Fifth Amendment. We agree and we affirm. Mr. Justice Powell, joined by the Chief Justice, has filed a concurring opinion. Mr. Justice Rehnquist has filed an opinion concurring in the result. Mr. Justice Douglas took no part in the consideration or decision of the case.
Thank you, Mr. Justice Brennan. We will...